Hello, this is the AI Lab. Today it's my pleasure to welcome Dr. Joan Barata. Joan is visiting professor at Faculdade de Direito Católico no Porto and works on freedom of expression, media regulation, and intermediary liability issues. The reason? A paper he wrote entitled Transparency Obligations for All AI Systems, Article 50 of the AI Act. Let's hear what Joan has to say. So, Joan, to kick things off, you note that Article 50 applies to all AI systems, not just the high-risk ones. And the European Commission is currently in a tight 10-month window to draft the code of practice related to this. So for listeners that are trying to catch up on how the AI Act functions, can you explain the core goal of Article 50 and why this specific drafting period is so critical for the industry right now?
So the Article 50 of the AI Act has a series of relevant provisions in the field of transparency of AI systems. And this means that there are some legal obligations for developers and deployers of AI systems to communicate, to make it transparent, to make it visible, so to speak, that a person, a user, is interacting with an AI system or having access to content created via AI. This is very important, as you may understand, in terms of protecting users vis-a-vis certain dangerous use of AI systems. But Article 50 only contains some general principles, general provisions, and there are additional standards in this sense, in terms of interpretation, but also in terms of technical solution, perhaps that need to be further established via regulation. And this is why there's an ongoing work in the creation of a code of practice. And this is why counting on this code of practice is a basic prerequisite for the competent institutions and the stakeholders to be able to enforce the AI Act in a consistent manner and according to the principle of legality.
Okay, so basically the code of practice will be the devil is in the details part of the article. um, now looking at your paper, you draw a sharp distinction between interactive systems like chatbots and systems that generate synthetic content like deepfakes, for example. Could you break down the difference in obligations between simply letting a user know they are talking to a bot versus a technical marking that is required for AI-generated media?
Here we are talking basically about different types of products, if I may call it this way, or services, options. In the first case that you mentioned, that is also contemplated under Article 50, we are talking about interactions. For example, when a user is interacting with a chatbot, and when there's a risk that the user may assume, may understand that he or she is actually interacting with with a human being. When this risk exists, there's the necessity, the obligation to inform in a proper manner the user that he is actually interacting with an AI system. That's the first type of obligation for a first type of use and even a first type of risk that is contemplated by the AI Act. But then of course, we encounter other types of problems that may also require a certain degree of transparency, which is the fact that which is the cases where the AI is used to generate synthetic content that might be seen or assessed as authentic by users when it is actually has actually been created using AI systems. And here there's a specific subcategory of content, if you want to call it this way, which is the deep fakes, no? The cases where this synthetic content is not only artificially generated, but also resembles real content, existing content, but actually it is we are talking about AI images, for example. And in this second case, of course, the risk of deception is even higher. And in these cases, of course, what is important is to make sure that in a transparent manner, that the user can be aware of the fact that the images that, for example, is contemplated are not real, when there's perhaps the risk that they are real. This is different from, let's say, the discussion about truthful information, about disinformation. This is a broader discussion, no? And even this is not a discussion on whether, or the law does not prevent the fact that we may use AI to disclose or to present false facts. This is not for the AI Act to tackle. This is not the problem that the AI Act tries to tackle. The important thing here only is to guarantee that if there's something that has been generated in an artificial manner, and there's a risk that those who have access to this content might be misled by the fact that it has been artificially generated, there are some measures in place to make sure that the user is properly informed that is having access to artificially generated content.
Okay, so I mean, at first glance, sounds good. Transparency, good thing. But one of your most compelling points in your paper is that there can be a backfire of too much transparency, let's say. And you mentioned that if we over-label content, we risk label fatigue, where users stop trusting any information. It's also called the liar's dividend, I think. Or we might accidentally hamper satire and artistic expression. So how do we balance the need to prevent deception without creating a boy who cried wolf scenario?
Well, I think that this is the key challenge for those who will be drafting the code of practice, because the law, as a matter of fact, establishes the general principles, establishes the general framework, but of course, when it comes to deciding the specific solutions that we need to be implemented, the specific principles that for each case should be applied, and also decisions on the trade-offs between the different principles that here are at stake: reliability of marking systems, interoperability, robustness, and also, I mean, the literacy, if we can call it this way, of the users, so that they properly understand what they are being told and what they are not being told by the labels. I think that that's the biggest challenge of the code of practice, and I presume that this is where most of the discussions among experts, civil society, etc., will focus in the process of drafting the code of practice. As you say, I mean, transparency is in order to avoid being misled, but sometimes too much transparency might be misleading. No? Because in a world where we may still have some reservations with regards to the use of AI, sometimes, I mean, the fact that someone use AI to show something and to make something look nicer, or to eliminate, I mean, certain shadows or certain, I mean, problems, for example, in a video like this, and then if you label that, and then there, I mean, some people in our audience may assume that I have been artificially created where I haven't, or that, I mean, you basically took this video of myself from somewhere, and then you use artificial intelligence to make me say something that I didn't say. But actually, we are just marking, for example, that hypothesis will be just marking the use of AI because we decided that we don't like the background, and we use AI to create a different background. That's it, no? So we need to avoid, in some cases, that being overzealous or having an extensive interpretation of the provisions, including in the Act, may create, I mean, a completely negative effect that is exactly the opposite of what the legislator was trying to achieve.
It would be interesting if we have to label every time someone changes their background. Looking now at the technical aspect, so the logistics, let's say, of Article 50. In your paper, you argue strongly that the implementation of the rules of Article 50 needs to be flexible, and that we shouldn't, or the Commission or the AI office shouldn't rely on a single rigid technical solution like a universal watermark, or something that is streamlined across all platforms, all content, all types of AI manipulation, let's say. If you could give one piece of advice to the people that are currently drafting the code of practice, and I believe you're involved, you're amongst those that are helping out or giving their views. So one piece of advice on how to achieve this flexibility while still remaining obviously compliant, what would it be?
I think, and I briefly mentioned that already, that I think that what is important is to talk about principles, not about technical solutions. No, exactly what we want to achieve at some point when it comes to a certain use of artificial intelligence. No, and again, then based on those principles, we might be able to find the different solutions, technical solutions that are best adapted to the kind of principles that we want to apply within a certain case. No, I think more important than pointing at a specific technical solution, that also, on the other hand, I mean, this is an area where changes may happen, where we cannot just point at one technology or something that now seems 100% reliable, but will be replaced in a matter of months. No, so I think that, of course, for those who don't have a legal background or more interested in technical matters, I mean, it might be particularly tempting to use the drafting process of the code of practice as an opportunity to discuss about the state of the art. But I think that, I mean, and perhaps I'm biased because I'm a lawyer, but I think it is more important in this process to discuss about the principles. I mean, and again, I mean, to understand the trade-offs, and also at different stages when it comes to different uses, what kind of trade-offs are we willing to accept? What kind of, let's say, compromises would be more aligned with the spirit of the law than others, let's say. So I think that this is why I insist on the need to take into account the principles more than technical solutions that by definition will be dynamic, evolving, and it would be a mistake to impose them through some sort of a regulatory instrument.
Now, as a final question, I think people now have a good idea of what your paper addresses. But I'm also interested in how you got feedback on that on your paper, because obviously, as we mentioned, the AI office has launched a multi-stakeholder process that involves civil society, academia, and industry to draft this code. But my understanding is that in developing your own analysis for this paper, you interacted with various stakeholders to gather their concerns. And what came out of that dialogue?
Sure. I mean, the first thing that, of course, I need to highlight is the fact that the process of elaboration of my small paper cannot be compared with the process of elaboration of the code of practice. No, it is more modest in terms of scope, in terms of consequences, and also in terms of consultation, the broadness of the consultation process. This being said, it's true that I try to consult with people with legal background, but also with civil society organizations that have specific concerns when it comes to human rights, with people who sit at the intersection between technical aspects and legal aspects, and also experts in artificial intelligence. So this gave me the opportunity to see how people who are not necessarily familiar with legal discussions see this matter, how the notion itself of transparency within the field of artificial intelligence triggers issues not only from a technical point of view, but even from a sociological psychological point of view, even, and also, let's say, philosophical point of view. No, for example, whether, I mean, being informed about something in this field already presupposes agency or not. Huh? Because even if we have information, does this mean that we are able to take our own decisions in a context that where the technological aspects are very important? I mean, does transparency in itself solve all the problems, or transparency is just a way to pretend that we properly dealt with something what we were supposed to deal with, but actually the user remains not properly protected? Well, these kind of discussions, I mean, I had the opportunity and the pleasure to have, I mean, with different stakeholders, and these, I mean, no doubt enrich my approach and my understanding of this topic, that was also mainly based on a legal approach. No? So that was also one of my, let's say, limitations that I try to counter by having these other interactions with all the types of profiles.
Well, it's always good when a lawyer tries to circumvent his limitations, Joan.
First, we need to acknowledge. First, we need to acknowledge. That's the first step. That is sometimes the most difficult one, and then we try to address as well.
Well, thank you so much for taking the time to give us the short version of your paper, which I encourage everyone to read. I found it certainly very interesting, and good luck with the drafting of the code of practice.
Thank you very much. We will all do our best.